has joined the meeting, so perhaps we can hear from him to start.
Well, thanks very much, William. Appreciate that. Yeah, I'm Paul Byrne, the founder and CEO of CPDOnline.ca. Oh, hold on. My phone's ringing. I really should take this. Oh, hello. You're a lawyer? Oh, you're a lawyer from Aurelia. Oh, you're a subscriber to CPD Online. Oh, that's great news. Oh yeah, you're just calling to tell us how great the CPD Online is. Yeah, thanks very much. Yeah, the content is exceptional. I'm glad you appreciate it. It's nice to get a call like this every once in a while from a happy customer. Yeah, the content is homegrown. It comes from Ontario Law Associations, and up to date, we post hundreds of hours every year. Oh yeah, the price, you appreciate the price. Yeah, $399 for a subscription. You're absolutely right. Oh, and the revenue generation for law associations. Yeah, you've heard about that, have you? Yes. It's $100 per subscriber is paid to the association to which you belong. Yeah. Oh, I know. It's an amazing way to generate revenue for the association. Just think about the number of members that you have in your association, times that by 100, and that gives you a sense of the revenue that can be generated by having your members become subscribers at CPDOnline.ca. Yeah, you're welcome. Thanks very much. I'm just talking to the executive panel right now. All right, talk to you later. Bye. There, another happy customer. I want to encourage you to have your members subscribe to CPD Online. It's got the best content, Ontario homegrown. The price is fantastic, $399 for an all-access subscription to the entire library. And there's a $100 payment per subscriber that goes directly to the association. That's it for me. Thanks very much. Hope you guys are enjoying your time.
Thank you, Paul, and thank you for your sponsorship.
Thank you.
I'm very excited to and honored to introduce our next panel. And it kind of comes home to me because one of the recommendations from the Truth and Reconciliation Committee was to involve law schools more in Indigenous law and teaching that. And I've had some really interesting discussions with my son, who's currently in second year of law at Western, about the program and the nature of it and his interest in it, which is, I think, a wonderful step. The one comment he made to me was, it's a bit of a disservice to the course that it's only a pass-fail. And I thought that really hit home for me. So we have a fantastic panel here, and their biographies are up on our website, and me trying to introduce them in that way is not going to do justice. But we have Madam Justice O'Bonaswin, Michael Johnston, Bryanne Smart, and our moderator, Christa Big Canoe. So Christa, I will hand over the reins to you, and we look forward to this session.
Just have one quick thing to mention. The Justice is delayed a little bit because she's lost her link. So Kelly, if you're on the meeting, can you get that over to her ASAP? Thanks.
Anine, hello, can you hear me okay?
Perfect.
Wonderful, thank you. Chimigwech, Anine Winnebujo, Christa Gichi Chimon, Nadishnakas, Nodenkwa Anishinaabe, Georgina Island Donjaba, Whippy Doden, Ogimakwe, Ganund Majig Gakina, Gui, Wabama Debwewin, Miigwech, FOLA, Miigwech to all of the panelists. So I'll just translate quickly. So I introduced myself in Anishinaabe, which is something we do when we're talking about our communities and our people in the land we're in. And so I let you know that my English name is Christa Big Canoe, that my spirit name is Nodenkwa Anishinaabe, Wind Changing Woman. I explain that I'm from Georgina Island First Nation. which is just north of Toronto, but that I live in Whitby. And I also explained I'm from the Otter Clan. Finally, I took the time to explain to you my current role, which is the legal director at Aboriginal Legal Services. Interestingly, we have no terminology for legal director. However, Anishinaabe people have always practiced Ganok-Nagawan law in our constitution, and we've always had advocates, Ganundamajig. And so we've had advocates in all areas of our lives, everything from counseling, family counseling to dispute resolution. And so the way it translated is I'm the little chief of those who advocate for all those who seek the truth. And that is the name, the Anishinaabe name of Aboriginal Legal Services. And so thank you very much for having me. I'm not sure yet if Madam Justice Michelle Bombswin's in, but it's an absolute pleasure today and I'm very grateful for each speaker sharing their lived experiences in working and navigating the Canadian legal system as Indigenous people, and to have Madam Justice Michelle Bombswin, Michael Johnston, and Bryanne Smart-On is an absolute pleasure, and I'm honored to be on the panel with them. And thank you very much to FOLA for inviting this panel. We only have a short time today, so in addition to hearing some of that lived experience and some of those best practices or some of the things that this panel is going to be able to provide you tips on, I think, one of the things that you're going to hear coming through the panel is this need to mentor and foster more Indigenous talent in the areas of law, but also learning to value, like the value you provide as an ally to the whole system and what it means to be a good ally. So I just want to confirm, do we have Justice Bombs? Oh, yes, I see. And so the first question for the panel is, and I'm asking each member to feel free to answer, but maybe we will start with Justice Bombswin. Can you share with us what it's like being an Indigenous person working within the Canadian justice systems? Or maybe you can share with the attendees one thing you think is important for all justice sector service participants to know.
So I have to say that joining the system as a judge, an Indigenous judge, it's something unto itself. So when you come in, I'll be frank, a lot of people will see you as the token nomination. So I've been named because I'm an Indigenous person, and I feel that there's always that shadow when you first join the bench. And at times it makes you feel like you have to prove yourself even more. But I have to say, colleagues-wise, they've been great and really allowed me to join them with open arms. So, but you do always have that fear in the back of your mind. And I think if you're not an Indigenous person, you maybe don't have this fear. If you're just your typical lawyer who's been named. And unfortunately, we do face some issues of racism, even when we're named a judge, where I had a situation after President Trump had called Senator Warren Pocahontas. And when I was sitting in court the next day, I overheard counsel speaking to each other, and one said to another, "Oh, she's Native Indian. She's our Pocahontas of the North." So, I have to say, I was totally shocked. I was mad. And I put it on the record, and I dealt with it accordingly afterwards. But I don't want anyone to think that just because you become a judge, everything goes away. It's still there. And I think what's important is how we deal and how we respond when these situations arise.
Thank you. Maybe I'll ask Bryanne to actually answer the same question, if you would, please.
Sure. Say hello, everybody. I was thinking about this question, and for me, I think it's realizing that not everybody in the system is going to know what you know. So as an Indigenous person, you're bringing a unique perspective, and what the other folks might know in the room is very different in terms of Indigenous people and cultures, and understanding what that looks like and what that means. So what I take away from that is there can never be too much education, and there can never be too much learning on this topic. There's always things to learn for everybody. And just, being able to understand that and realize that and find ways to move forward, that we always have ways to go.
Thank you. Michael, I'm going to ask you the same question, please.
Can you hear me now? There we go. Um, you alluded a bit to this, Madam Obonson, in that even though you enter the field with your own credentials, you still have a higher, there's a slightly higher bar. You have to be as good as everyone else, just a little bit better than that because of the burden of being an Indigenous person as well, and more eyes on you. And I think that my experience perhaps echoes some of that, and similar to women properly entering a lot of fields, they find that they have to do better than men in the field already. Indigenous people in law, where we're using the tools that are unfamiliar to a lot of our cultural backgrounds, we have to do slightly better at them to get the same level of respect, and not only from the outside but from the inside as well. And it might be a curious observation, but I find that part of my obligation to do well, to be a good lawyer, is to my own community, to demonstrate to them that I'm as good as all the non-Indigenous lawyers are available to represent them. And so honestly, I feel like I'm straddling a line or living on two sides of a fence, and trying to be good enough for two groups of people at the same time. So I think that's a relatively unique challenge for Indigenous people in general, but I'm sure that some of our female and maybe people of color counselors also have that same sort of experience as well.
Thank you, Michael. And it's so valuable to hear from each of you. And it's kind of nice as an Indigenous lawyer to hear from other Indigenous legal practitioners, because I think we have some shared experiences, right? And so in that, we know collectively we have people we can talk to as well. And I have always found the Indigenous bar and legal professionals to be very open to having those conversations to talk about best tips and practices moving forward. We do unfortunately still face a lot of stereotypes, a point that Bryanne made in relation to like people's assumptions or stereotypes. So I'm often not seen as Indigenous, but with my last name, you can guess I am. And so we're often navigating through systems where people just don't have the knowledge or awareness, and increasing that knowledge and awareness is, I think, invaluable. The next question that I have for any of the panelists who would like to answer is to maybe talk about the progress that's already been made that we have been able to see during our careers, and the progress that's still needed. And I'm not sure who would like to go first here. Maybe we can start with Michael.
I will start. That's a big one. That should be like several small questions. That's a big one. So progress that has been made. I'm going to defer on progress that's actually been made within the law itself, and I want to talk a little bit about education, because that's fairly close to me still. I'm a relatively new call. Just so everybody knows, I was called in 2018. And my experience in school was challenging. I won't try to decorate that too much. I found it challenging because going to Osgoode, where I went, I was very conscious of Osgoode's history, if not that physical building. We were at the York campus, but Osgoode as a law society, as the founder of the Law Society, I was very much aware of the history as I was studying there, and the fact that institution had been there at ground zero, in effect, for a lot of the things that were happened or justified or rationalized under various ground systems, doctrines, programs, and so on to Indigenous people over the years. And while I think it's grand that the law schools are required to teach Indigenous, I don't want to say history, but Indigenous background courses in their first year, I think that's super valuable. I was really surprised at the number of people, though, who I met in law school who have a degree, who have life experience, and would astoundingly ask, what's a residential school? At this point in history, I think that everybody in law school should know that. And we don't yet. The good thing, the thing that we've accomplished, is that we've got standards in place now across the country that new law students are learning that stuff, and they're learning it in first year and not in fourth year. And I think that's the right time to learn it, because it can color what happens. And certainly some of my colleagues at law school learned some of this stuff in first year, and it changed where they went in second and third years of their law school experience. Where we can do better is perhaps get some of that stuff into our schools before people get into law school, maybe put it in an undergrad so that some of those questions are pre-answered. Yeah, that's where I think we can and have done do better.
Maybe I will turn to Madame Bonswan to also respond to the same question about progress, what we've seen or where we need to go still.
So Michael made really great points on the education component. And I always tell everyone the first starting point is to read the summary of the TRC report, because I think that that gives everyone a good understanding of where we've been, the issues that we face as Indigenous people, and hope for looking towards the future and reconciliation. On the legal side, on the criminal side, I've seen progress, legislative side, where in 95-96, the government of Canada introduced section 718(2)E of the criminal code that gives us as sentencing judge now the obligation to look at the systemic factors that impacted the individuals that are in front of us that are Indigenous. With regards to sentencing, 2 years ago, there was another amendment for it to be an obligation for us to look at the same factors when it comes to the provision of bail for Indigenous accused. And those are things that are very important. And all the different commissions in the past 30 plus years have told us that a serious issue is with regards to the over-incarceration rates of Indigenous people, where right now they're atrocious. They're approximately 33% for men, and the most recent report at 41% of the population incarcerated female population are Indigenous women at 41%. So we were hoping in 95-96 with the amendments and the provision of 17(2)E that we would see a lowering in the incarceration rates, but the Supreme Court of Canada confirmed, because of all the evidence that was provided in IPELI, that the rates have unfortunately continue to go up instead of down. So where we have work to do is very much on the social context, and it starts at the child rate moving all the way up. Right now we have 40% of children in care are Indigenous. So what we have to do is deal with that issue. I think that has to be tackled right away. And if we could start taking care of this issue of Indigenous children in care, it's going to impact also future lives and future criminality issues. So I think that there's, in the social context, education is the key for all non-Indigenous people to understand where we've been, where we are now, and where we're going, and also to deal and tackle with the issue of all Indigenous children in care, and how could we turn that around to improve lives.
Thank you. I'm going to turn to Bryanne. What have you noticed in terms of the progress that we've seen and progress that we need to move towards?
Yeah, I think about this around, that piece about education and understanding. And so also realizing that the experience of Indigenous people are and also can be just fundamentally different from those of the settler population and those of the people who are working within the court systems. But when you see that representation in the court process and throughout the entire process, you kind of have one less step to take to come to a better understanding of each other. So one thing that had always sort of stuck with me when I was working with Indigenous folks is that you tend to relate your own experiences into stories. And when you think about Indigenous experiences as a settler, that measure is just way off, right? You relate to your own experiences as a 6-year-old, for example, and the experience of an Indigenous person or child at 6 can be worlds apart and worlds different from what you've experienced. And so that can be really hard to relate to. And so I think that seeing and having a fundamental understanding of those people who are represented leads to better understanding, better relationships. And I think this is one of the important things when we talk about something like Ladue report. So why sharing that is so important, because you can understand and really have a deeper appreciation for what someone has gone through without having that direct understanding. So I think that that's something that we see and is important in representation, right? You're already sort of at a similar level with the folks that are coming through the system when you're sitting on at those tables.
Thank you. And that last point, definitely, Bryanne, in terms of the representation, like we look and we heard Madam Abomswan and Michael Bowe speak about, those different worlds. Like we find ourselves a minority group in education and academic institutions and legal profession, but we see ourselves, and I don't even use the word overrepresented anymore when I talk about what is also called the crisis of Indigenous incarceration. I say over incarceration or mass incarceration of Indigenous people. We well surpassed the crisis. When they changed the law back in 95, 96, when we had Gladue in 99 and Ipili in 2012, it's always characterized as a crisis. The crisis has been decades long. Crisis seems to imply that it's something that's happening that we're going to be able to resolve if we put attention to it, and that's not what's happening. So the acute mass incarceration of Indigenous people is something that we have seen the law itself and language progress, but we actually need to see practical implications changing and moving forward. So there are some good wins when we talk about things like Gladue reports or the court being able to take into account a number of things. And the way I tend to see this issue, and I often use the example of R. and Barton, which is a case that went up to the Supreme Court that was about the death of Cindy Gladue, and the fact that at the first level, Miss Gladue was often referred to as Native prostitute, Native sex worker, Native girl, Native woman, and not by her name. And then in the decision in Barton, we have the court actually give explicit instructions to other courts and counsel about the use of her name and the fact that she's an Indigenous woman, and that makes her experience the world more vulnerably, not her herself. And they make these great statements about how everyone has to recognize and take into account Indigenous women, and that they're not less than worthy victims. They're absolutely worthy victims. So in one way, that sounds like there's been progress made, because here's the Supreme Court of the country telling us all to do better. But then you have to take into context, that's the Supreme Court telling us in 2019 that we have to do better when it comes to Indigenous women as victims before the court. And why are we saying it out loud in 2019? Why weren't we already doing it? So, progress can be this funny place to navigate. Michael, you had been talking about when you attended law school, how there was some colonial law taught, and it's within a colonial institution. Can you tell us a little more about that experience? And can you also tell us, you also mentioned you're just a more recent call. What was your first profession, and what was your experience going through school following that first profession?
Thanks for that question, Christa. I'll do this chronologically and tell you what I did first. So my first degree, I have a Bachelor of Science in Applied Computer Science. I spent 25 years writing capital market software. And then that was all fun and grand. But I literally was lying awake at night wondering what I could do more. I wanted to do more for my community. I couldn't think of how to do it. And believe it or not, when I looked at the people that I respected most, a lot of them were lawyers. And I thought, well, those are some great legally trained people that have changed the world in ways that I think were for the better. I'll follow them, because I think the best way to succeed is to follow closely in the footsteps of somebody that's already done it. So off to law school with my wife's permission, of course. And I found, having got into law school, which wasn't surprisingly that hard, but having got in, I found it a fairly alienating experience. And again, I don't want to romanticize it or woe is me. But again, that idea of learning the rules, learning how to use the tools that they use to subjugate and disenfranchise your people, your history, that made me uncomfortable. It made me question myself. Was this right for an Indigenous person to do? And I think that's a fairly unique question for Indigenous people. And I mean, imagine if you're from a demographic that's been predated on at some point in history, if you had to go to that place and then learn at the knee of the people that had aggrieved your ancestors or even your people, what does that mean for you? Are you now, in bed? Are you, I don't want to make uncomfortable historical comparisons, but it was challenging for me to go there and to learn that. And I'll be quite frank that I spent as little time literally in the building as I could. I would go for my classes and then I would leave because I felt really uncomfortable there. And I mean, they're doing a good job. They've got some art on the walls, and they would have occasionally a visiting artist in with an Indigenous background who would put something up. And that's great. I think the dean was passionately and sincerely on side, a supporter. But the dean's good attitude didn't wipe away generations and a couple hundred years of history that we're not going to forget. And I think in learning the law, and I'm interested in my my fellow panelists what their experience it was, but in learning the law itself and learning those fundamental cases that have been developed particularly in the last few decades, that lead to where we stand in Aboriginal law today, to use the technical term. In reading those decisions and learning those decisions as an Indigenous person, we don't make the same A, B, C logical conclusions that perhaps the justices made in reaching those decisions. And in fact, we see A, J, D, P, and the decisions jump around because they often look like they're a post-rationalization for something that the Crown or the justice wanted to happen. And again, that's the perspective of an Indigenous person learning a decision written by a non-Indigenous person who's, well versed in decades of law. But this is a perspective, and it's a perspective shared by a lot of Indigenous people. And that's kind of the point, that we're at a place where Aboriginal law doesn't make sense to a lot of those big air quotes Aboriginal people. Does that answer the question? I hope, Christa, I wandered there.
Yes, thank you. Thank you for sharing and your candid response. I want to ask Madam Abomsawan if you can share with us what was, in terms of joining the bench. You already touched on it briefly in your first response, but maybe as part of your perception or any tips you could talk to us a little bit about what it's like joining the bench.
So just to give you a bit of background, it's always important, and I always tell the students all throughout my career, I give them the same advice I got when I started. You only have one reputation. Make sure you guard it well, because if you lose it, you won't get it back. And if you're interested in joining the bench, it's important that you have a good reputation. So when you're dealing with lawyers that you necessarily may not enjoy working with, always be respectful, because at the end of the day, when it's time for the commissioner's office and the minister's office to start looking into your background, these are things they're going to look into. Are you a fair person to deal with? Because they're not just going to look at the references that are on your application. Don't be thinking that that's the only people they call. They call others. They call judges you appear in front of. They will call colleagues. They will call people that you argue cases against. So there's much more of a digging into a person if there's an interest for you to be named to the bench. So always be mindful of your interactions with others and to be respectful, because it's very important. And when you join the bench, it is a learning curve. I don't think many people join the bench and they think, and they start right away and it's easy sailing. It's a lot of hard work because I didn't practice in family, for example. So I sit in family, civil, and criminal. So I had to self-educate myself about what laws are in practice, what are the tests for certain things. I got myself a mentor who's held my hand when I first started, to get to ensure that I was on track, and when I was considering things that I was always on the right side of the line. So she, and that was Justice Odette, was exceptional. She was named the first day, the same day as I was, but what was important was she had that experience that I had lacked. So I would tap into the resources that I could and read as much as I could. So it's a wonderful experience, but just be mindful that your reputation is important. And once you start, it is quite a long, not a long, but a large journey to make sure that you get up to date in the different areas of law, especially if you're someone like me who didn't specialize in family, for example.
Thank you. Those sound like some great tips. So, Bryanne, I have a question for you. And so I've got a two-part question because you do system navigation and assist clients through processes. Can you tell us first a little bit about that? And then maybe can you talk about the importance of the client relationship in helping people navigate through systems?
Yeah, I was a GLADU writer and a caseworker in courts and worked with criminal defense for a long time. And I think what the importance of these relationships is just that, it's the relationship. And I think it's to help navigate the process. And I think about these, Indigenous accused or offenders, or what we want to think about coming into that process and coming into a colonial system like Michael shared, and how difficult that can be for folks to navigate through. And so the importance of having someone to help them through that is so vital. I remember I had an elder share with me during a GLADU court process once about Indigenous people finding themselves in conflict with the law and part of a system that they are not familiar with, and similar to that vein, something that was just stacked against them this all the time, right? And how it's easy to not want to take part in it, but what's not easy are the people that have to do it without help. And so it's important to have those relationships and to have people sort of on the ground, caseworkers, court workers, whoever it might be, to help the people who are finding themselves in those positions. Because I think what you have to think of collectively is, how do we support their journey from beginning to end? And what does that look like? How does that feel? And I think that if court workers or GLADU writers or any of those people weren't there to help, how much more difficult that process would be. So I think that these roles are so vital in a number of ways. I think that caseworkers and court workers, they have time that lawyers don't always have. So I think that they can really spend time to create healthy and safe relationships with people, and not only around familiarity about Indigenous protocols or ways of knowing or culture or what have you, but also around the entire operation of the court process. So I had clients, when I worked with them, some of them were, very familiar with the system. They'd been there before, unfortunate but true. They know what to expect. They know what to have happen. They know what's going to come next. But I'd also worked with clients who had never been there before. They were maybe younger or first-time offender, and they're terrified and they're scared and they don't know what's going on. And so to have somebody to not hold their hand, but to support them and to work with them through that process. The language can be confusing. They might not know what that means. I've had folks come to me after and say, I don't know what just happened in there. I don't know what those words meant, and it went too fast. And so having that opportunity to have someone that you feel comfortable with, and have someone that you can feel supported by, and that can really help them through the process, help them understand. And one other thing that was, that we could do is, even when we were talking about GLADU and going into a sentencing and having worked with them through that process, is then to prepare them for what it's going to look like. Okay, now we've done all this work. Here's what's going to happen when we get in there. And being able to walk them through that process so it's not shocking. It's not, you're not on your own. You have somebody who's there to support you, and you can really walk them through what's going to happen next. So that's what I think is important. I think that those who are assisting in the court have have time and can spend working on those relationships with people. I remember I had some folks who were like just hardened, and they were like kind of mean, honestly, like they didn't want to work with me and they just didn't want to be a part of it. And so I had the opportunity in that time to approach it with time and care and sort of work with them to get past whatever was the difficult piece. And it really transformed into healthy relationships, and we just worked through things together, and it just changed the entire approach of somebody and what their process looked like through the court systems. So I think all that is to say that relationships and building those are the most important thing. And that's what's so great about court workers or case workers or GLADU workers or any of those people who are on the ground helping people through the process. I just think it would be so much harder to do that without them. And I think I hope, and in my experience, it has left a better experience for folks going through the system to have people to relate to on a different level and just to be connected with.
Thank you. I think that's great, and I'm so glad you spoke to the relationship and your role in assisting individuals before the court, because I think sometimes lawyers forget that. And I've actually been in circumstances where I've heard lawyers talk to, for instance, a Native court worker, be like, "You have to get this for me," and I've actually stepped in and said, "No, actually, they don't, because they are representing that individual. They're not your staff member." And so it's important, though, that relationship we build with everyone in the courts. And you spoke about a number of workers, but we can make that analogous to victim service workers as well, that help victims navigate through court. Without these people as part of the system, I can't imagine how our jobs would be when we step up as proxy professional, this highly legalese, lots of language words, without some of those buffers. Now, I always personally, as an Indigenous person representing Indigenous people, try to empower my clients to understand the system, which means more time, which means explaining concepts, including legal terms. But I think part of the whole relationship aspect, and I do see lawyers and other legal professionals being kind to each other, and I do see, so I'm not saying it's all bad, I do see, good behavior. I do see people respecting each other. But if we did that in every relationship and encounter we have within the justice system, I think you would actually see a little more integration and cooperation. But thank you so much, Bryanne, for sharing your perspective on that. I think it's an important one for lawyers and legal practitioners to take into account next time they're if we go back to open courtrooms and we're working hand in hand with these various workers, how much maybe gratitude we might think in our minds we might have when we think of different perspectives. I'm going to move forward in my question, and again, it's for all of the panelists to answer, and it's specifically about GLADU Court. So, I'm going to leave it very broad, and we can sort of drill down a little if we want, but what do the attendees in today's session need to know about GLADU courtrooms, especially from our court in general, especially from your point of view? So what position you bring? What is it attendees need to know more about the GLADU court, the process, the law? What would your best tips be? And maybe we'll start with, I'm trying to not go the exact same order every time, but maybe we'll start with Madam Abomswan.
So in our court, we don't have a GLADU court. In our courthouse, there is a GLADU court at the provincial level. So I can't speak too much about that, but I can speak about my extensive research I've done for my PhD about GLADU principles and what we should be considering in the court system. And one of the important things is it's not always necessary to have the GLADU report. Of course, we want it. It's the best source of information. But at some point, if we can't get a fulsome report, I, as a sitting judge who does not sit in a GLADU court, but does do sentencing and bails, I will take a letter as long as there's that information that I'm looking for. So what's important for me to know is about that person. I don't need to necessarily know about colonialism, about residential schools. I know about those things. I'm an Indigenous person. I know, and I have firsthand knowledge about that. What's important to me is the information that relates to the individuals in front of me. Where does this person come from? Is there intergenerational trauma due to residential schools? How has that impacted this person? Does this person come from a reserve? Does this person come from off reserve? What kind of services are available for this person? So this is the core information as a sitting judge that I'm looking for. Gladue reports are always the best source of information, but at times we can't get those. And if I have all that information in a letter, or I have someone who could come and testify from the community to explain this to me, and to also hear from the Indigenous person, him or herself, I think that those are very valuable to me as a sitting judge, and that's what I am looking for.
Thank you. Maybe we'll go to Bryanne now, because we know you've already helped us understand a bit about how you navigate, but if you can tell us a little more, that would be great.
Yeah, sure. When I think about Gladue Court, I think about like feeling and how it feels different. It's just a different way of approaching people, and it's so special and it's different. And I think that feeling comes out of it in any Gladue Court that I've been a part of. And keeping in mind that thought about relationships, it's a place where you do build relationships, because it's a different process where it allows for conversation. And the ones that I've experienced, it allows for people to share. And, it's such a different process. I remember one of the first opportunities I had in Gladue Court, the client came out and he was just like, oh my goodness, like, how did I get to talk so much? How did I get to share so much and have a conversation with the sentencing judge and the lawyers? And I also understand how difficult that can be to sort of let your client speak up and share things, but just there's a certain level of understanding and again, honoring those relationships and finding ways you can go from them. I think it's a place that is really uniquely respectful of rules. It's about kind of all coming down to the same level and really working to understand each other in a respectful way, still understanding that the judge is the judge and the lawyers are the lawyers and the client is the client, but being able to approach things in a different way. I've seen such great things happen in Gladue Court, and those experiences they'll stick with me forever. I mean, they're a place they can be emotional, they can be transformative. And I think it's, I had the opportunity to be in circles that were, it's not circles, but, in sentencings that were larger, and they would allow for family to share and service providers to come and share, and to really come up with such a fulsome plan or an approach for what's going to happen next. And, so being mindful of that is that it's an entirely different operation of a court process. It can take a long time. So to be prepared sort of for what that could look like. And, that it really gives an opportunity for an Indigenous person to be heard in a way that they haven't been heard before, where they haven't had the opportunity to share about themselves and you're guilty, not guilty, whatever that looks like, but an opportunity to talk and to share from their own perspective. And even, you can see them relate their own experiences in the past to how that sort of led them to where they are now and what they need to do to fix that or to change that or to see what's going to happen differently. So I think it's just, I feel like I could talk forever about Gladue Court. I spent a lot of time there and I loved it. And I just like the feeling. I think that's the most important thing, is that it creates such a different atmosphere, and it allows for like real change sometimes, that might not have otherwise happened if you think about the traditional court process.
Thank you for sharing. Michael, what would you like to add?
And I'll add briefly to Bryanne's great comments. And I probably don't have to say this to the assembly here today, but Gladue Court isn't about an offender dodging an appropriate sentence. It's about the court and the system finally coming up with a kind of sentencing that is appropriate for the person. And that's absolutely key, because we we understand that Madam Justice's earlier comments talking about or Christa, perhaps it was you talking about the levels of incarceration, despite Gladue courts, levels of incarceration are going up. So the kinds of tactics that we're using, while admirable, aren't necessarily working. But that's not what Gladue is about. Rather, it's not about dodging appropriate sentences. It's about finding an actual appropriate sentence that will address the causes of mass incarceration. So, to echo what Bryanne was saying, it's about the feeling, and I'm glad that was the first thing that you said, literally in your first sentence. It's about the feeling. That's really the point of it. This is not an Old Testament kind of room where it's an eye for an eye. It's about finding what's best, not just for the offender, but for society, that person's society and our joint society as well. So the best path forward isn't necessarily, the mandatory minimum. It might be something different that works to rehabilitation, right? We have to believe in our profession. We have to believe that these things are possible. And we have to believe it passionately, that we're not in the business of lashes, but we're in the business of rebuilding. And I'm sure everyone's seen this by now, but I do want, if everyone's got a pen handy, to make a note here. The decision of Nakatsuru in 2015, Ontario Court of Justice, it's 2015 ONCJ 64 on Canley. Read that decision. It is equal parts heartbreaking and uplifting, and it's what every decision we ever wanted to be. It's all there. It's the kind of decision that you wish you had written. And
Is
it
that
says
the
a lot
Armitage?
Yes, Armitage, RV Armitage.
It's incredible.
It's such an important decision, and it's an easy read, and that's one of its beauties. So if you've got 20 minutes today, find that decision if you haven't read it already. I keep it pinned because it's inspirational to me as an Indigenous person, but I think it's inspirational to our profession as well.
Thank you. And again, all of these responses are like such a good insight from different perspectives, but also come together so well. One of the things too, so as you know, I'm the legal director at Aboriginal Legal Services. We have a program and have probably been the longest standing organization to write Gladue reports. We also intervene in various appeals as it relates to Gladue sentencing principles, and we're often arguing kind of novelly in law, other areas of law where the types of Gladue principles should be put into place. We do a lot of work advocating before Senate standing committees and in changes of law. And so, Gladue is kind of an area ALS has been quite involved with. Their program side under Jonathan Bruden was actually very important in the creation of Gladue courts as they exist in Toronto. And we now have, we started off as a fairly small mom and pop shop some 30 odd years ago, and we now have 73 staff, 15 who are Gladue writers, and another 13 who are Gladue aftercare, which is to say, when this connects to what Bryanne was talking about earlier with the participants in the courtroom that actually assist the whole system, that make the whole system a better place. Aftercare workers are those same types of people. So remember, if you go through the case law and if you have a judge that's applying it properly, you have Crown and defense that are both sort of making the submissions as they exist in law, and you're in the best circumstance, there's still better opportunities to make sure that individuals, the second part of the Gladue test, what's the most appropriate and fit sentence, is being done, is to ensure that there's aftercare or support for individuals going through the system. And so, we don't, in Indigenous philosophy, and I'm going to speak Anishinaabe because that's my background and what I understand, there are some sort of universal truths, but I can't speak for other Indigenous groups. When something happens that disrupts the harmony and balance within our communities, the repair or the rehabilitation is more than just about the offense. That's the big difference between Canadians' criminal justice, very narrow approach to whatever happened that led to the offense, versus an Indigenous approach that acts the whole looks at the larger picture, because you don't get to a solution necessarily under the sentencing principles that exist outside of 718E, right? When you look more at the fundamental sentencing principles that exist within the Canadian criminal code. And so what that looks like in reharmonizing or rebalancing is, what is the safest community? And for a lot of Indigenous people, the safest community isn't mass incarcerating Indigenous people where they learn to be better criminals, where they get involved in gangs, where they come back, maybe never having even tried drugs, but come back addicted into substance use. And so that rebalancing requires, though, community support. Right? So something like Glad You Aftercare is something that when someone's going through a sentence or going through community sentence, that they have the opportunity to actually meet, and in a supported way, the obligations that they should owe to the community, be accountable to their community to rehabilitate, as opposed to this kind of very theoretical justice system or the Crown. And that's all that I wanted to add to that context. Because I think we could spend, like, you could do an entire day. In fact, we've been part of conferences, and ALS has put on conferences where it's a day or two just on GLADU. So scratch the surface, but I think definitely some helpful advice and insight from today's panelists. One of the, probably the last question I'm going to ask panelists is, and I talked about this up front. So one of the things that's really important, I think we see more and more Indigenous people going into areas of law and practicing law, and that's a good thing. And we see, finally we're seeing more judges appointed to the bench, and we're seeing a better representation, but we're not there. If you look at the Law Society's report, the Law Society of Ontario at one point did a diversity report, and it talked about the fact that 2% of Ontario's 1.8 to 2% of Ontario's population is Indigenous. And look, so is our bar. We're about 2%. But then if we talk about that over incarceration, if we talk about the mass incarceration, if we talk about the over apprehension of children, the numbers and statistics of Indigenous people involved with the Canadian justice system, then we see an underrepresentation of Indigenous people. But there's also ways to look to our colleagues and as allies to assist in raising the bar and changing some culture. And so I want to ask each of you, what advice do you have to either Indigenous people working within the system or any of our allies? And maybe we'll start with Michael this time.
Wow, that's a broad question again. You always throw down the glove, and it's a giant glove. I'm going to come back to education again. So, awareness. I mean, we have awareness for breast cancer survivors, and we have awareness for Indigenous issues, and we have awareness for immigration. So awareness becomes a bit tawdry and overused, but it's actually fundamental to all of our approaches to the work that we do. If you have an Indigenous client come through your door that needs your assistance, you would be well equipped in the law, of course, but equally well to understand where that person came from. Whether they're like me, they came from a reserve, or whether they're an Indigenous person that was scooped, ended up being raised outside their community, but they still have this lived experience as a disenfranchised Indigenous person. Be aware of those things. Understand those things, because they're going to, in part, direct the sort of help that you're going to give, what path you want to take them down. Because the solution that seems apparent, I think, to lots of non-Indigenous people, or perhaps to the justice system, the solution might be something different. The solution might look to something more internal. So just in the same way that a GLADU court can lead to a different kind of sentence more appropriate to that person and the offense, in the same way, being aware of your Indigenous client and understanding their background and their history might lead to a different kind of solution that you're bringing to them, whether it's in the area of criminal defense, which is fairly constrained, but maybe it's in family law, where I do a lot of my work, and working with kids. Different solutions. So instead of just saying, I'm going to take the kids, maybe there's a different solution that involves the family more and satisfies the parents more, and that's more directed by their community experience, where often what I see is that we're not saying it's just a matter of who gets the kids, it's where are the aunties and uncles? Are there grandparents? Is there a community caring solution that we have for these kids so they don't get pulled one way or another, and that they're still cradled not only within their family, their nuclear family, but within the community family, which is just as important to Indigenous people, particularly those living in their home communities.
Great, thank you. I will turn to Madam Justice Abomswin.
I think it's important that we share our knowledge with others that we work with within the system. So for example, I'm a big proponent. I've written a lot about the use of GLADU principles in our court and in the forensic mental health system. So I've shared writings on our intranet. That's our internal internet system. I speak at a lot of conferences because I think it's really important for all those that work within the justice system to get a good handle of what GLADU principles are, how they could apply to the system. Is it unique to criminal justice? Is there a possibility of a consideration of the type of systemic factors when it comes to child welfare? So I think also it comes to relationship building. And there was a good conversation about that at the beginning here, where it was discussed relationships are very important. So by building relationships, sharing our knowledge with others about the things that we think would be beneficial with regards to our Indigenous population, I think that's really the key, and to education.
Thank you. Bryanne?
Yeah, so just to echo my fellow presenters, I think it's that, just to flip the narrative, right? We think we've understood for so long that, and taught through decades of colonialism that Indigenous folks are less than, or they don't know, or they don't have the knowledge, they don't have the process, they can't do it. But I think, Christa, you said this, listen to them, learn from their systems. They had them in place for even before contact, pre-contact, all of those things, to think about that. To really go back and listen to some of the Indigenous people and Indigenous things that are being presented. It's that whole concept of learning but unlearning, right? Unlearning the things we knew and learning the things that we can do differently. The idea of not being afraid to be disruptive. And I know there's certain confines that we have to work in, but find alternate ways of doing things, different sentences. Michael, you said this, finding ways, finding external family, looking at that type of thing. It doesn't always have to be status quo. And if we keep things status quo, nothing's ever going to change. And I think that that's something that we have to do, is look to make change. And so that's what I wanted to say. And then also to my fellow Indigenous family folks, brothers, sisters, just keep going. I know how heavy the work can be sometimes. I know how heavy it is to work with clients and to feel bogged down and feel tired working in this system, but to keep going, because you're needed. You're so needed, and the work is needed, and the people need you to be there to support them. And I just I can't stress that enough, but take care of yourselves at the same time, because it's hard work.
I just want to add, active listening is really an important point that she just made, because sharing our knowledge is important, but listening to our communities is also extremely important.
Absolutely. And thank you, Bryanne. And I just realized the last time I introduced you, I said Bryanne, and I added an extra A, but I know it's not an extra A. Definitely. Those are very helpful. I think pearls of wisdoms from real practitioners that have experienced and had journeys along the way. One of the really important things for me, and I just did this recently when I was doing some judicial training, is I challenged the bench to consider not just intergenerational trauma, because we often cast all experiences, particularly in criminal or in child protection matters as, oh, look at all of these things that are going wrong, or look at all of these hardships. And what we forget to do is look at intergenerational strength. So intergenerational strength is something that exists. And how do we know it exists? Because assimilation or genocide didn't work. We still have Indigenous people with Indigenous languages, with those stories that they can tell and that knowledge they can share. One of the points Bryanne made about, flipping it on its head is often I think we fail to consider as legal professionals that Indigenous legal structures, rules, principles could actually benefit more than just Indigenous people. Some of the philosophies and some of the legal principles that we rely on would actually benefit everyone in the justice system in terms of, and I don't just mean, Indigenous accused or offenders, but every single part of the system. We could improve and make better on the system. And so I think one of the common threads we've heard throughout today is this concept of grasping the knowledge or taking the knowledge. And so I had just put into the chat a link to Indigenous educational resources from an Indigenous organization and business called Good Minds. And they have tons of recommendations. One of the things that you could do, a challenge from me to you, is not just learning these like dire situations, as we go across the country uncovering little bodies in mass graves or unmarked burial graves, that we also have to look to the resilience and some of the strength the Indigenous community has, which includes some of these great stories, some of these great ceremony, some of this great culture. And a way to do that is to actually not just broaden your knowledge as it relates to specific case law or issues from like things like the Truth and Reconciliation or the National Inquiry into Missing and Murdered Indigenous Women and Girls, but also like real stories of real people. And so take a look at that. You might find something, the Good Minds link. I have recently been recommending Jesse Wente's book because Unreconciled it's called, because it's a contemporary story by a voice we can identify, and we can see what the impacts of being Indigenous in contemporary life looks like. So it reflects a little on the past, but it talks about the here and now. And it comes from an author who himself says and explains that he comes from a place of privilege. Like he was a CBC, Canadian Broadcasting Corporation reporter and for a number of years, and a film critic. And so he stands in a place of privilege and he explains how he's impacted. And when you hear how he is impacted, then you can relate what that must be like for people before a system that hasn't necessarily been fair to them and has always sort of had a deficit approach. So one of the things I hope that the message that came through in this panel was we also have to look to generational strength, and knowledge is power. And I really want to take the time to thank all the members for being so candid and honestly sharing. This leaves us a few minutes. If there are any questions from the attendees, we might have a moment to answer a last question. I haven't seen anything come up in the chat, but if you if you do have a question, there's an opportunity to put it into the chat, I believe.
We've sort of been imposing a 10-second rule. So if there are no questions after 10 seconds, we call that as a no questions.
Whoa, you guys move fast. So again, I just want to extend a huge amount of gratitude to each member of the panel and for letting me also share some of my narrative through this process. And I think, we've taken some tips away, but we've hopefully impugned some tips on you, and you can take some of those tips away and sort of rethink or take that moment to think about what we can do for best practice. So Chimi Gwech again to each and every member of the panel, and for inviting us to come talk about these important issues.
Thank you, Leonie. Merci beaucoup.
Thanks very much. It's been a pleasure.
Thank you, everybody.
Thank you all very much for attending and sharing your knowledge with us today.